Nancy John Lane with the North Carolina Down Syndrome Alliance, and we would like to welcome you to the North Carolina Down Syndrome Alliance virtual speaker series, and it's hosted by us, the Down Syndrome Alliance, as well as Coastal Buds, Down Syndrome Network of Onslow and Carteret Counties, Down Syndrome Network of Greater Greensboro, Down Syndrome Association of Greater Winston-Salem, Down Syndrome Association of Greater Charlotte, and the High Country Buddy Walk. And we just want to thank you for joining us tonight. And we are so excited to have Mark here with us from Clarity Legal Group. And he is going to be presenting a legacy of love and what every parent needs to know about special needs trust. So we are in for a treat and having him tonight. So thank you, Mark, for being with us. If you do have questions throughout the evening, we ask that you drop them into the chat and we will address them at the end of the meeting. If you have to hop off the call, we will do a follow-up email with those questions addressed as well. So please just feel free to drop them throughout the evening, but we will take it after his presentation. So take it away, Mark. Thanks for being with us tonight.
Okay, thank you very much. I'm very happy to be here and am excited about this presentation. It's a version of a presentation that we have obviously done before, but one that we have a lot of satisfaction in, because I think it is basic enough to give a context for people who don't have a lot of experience, but useful for people who may even already know a significant amount about the subject. So I'm not going to try to cover the whole world that relates to this, but I'm going to give an in-depth primer on trusts and where what's called a special needs trust or a supplemental needs trust fits in that picture. I want to give a thanks to the North Carolina Down Syndrome Alliance for inviting us to do this. We are, like I say, are really passionate about helping folks who have families with anybody in the family who has needs to have a special needs trust, and it is a privilege to speak to you guys tonight. Let me introduce myself a little bit. I'm one of a number of attorneys at Clarity Legal Group. We don't do anything other than estate planning, special needs planning, and what is sometimes referred to as elder law. We are a firm that's been around in the Triangle for a while. Our offices are in Chapel Hill right now. My background is doing nothing but this area of the law for about the last 30 years. That was my dog, Phineas, in case you were wondering, and hope we don't hear from him again. I have been practicing in the Triangle since the late 1990s. I practiced in Greensboro for a number of years before that. Clarity Legal Group is, as I said, an estate planning firm. We don't do anything other than estate planning, special needs planning, related asset protection planning. Special needs planning is a big part of our practice. I started doing planning in this area about 23 years ago. And as it has evolved in our practice, we have begun to develop it as really a specialty sub-practice in this sense. It's always been my experience wherever I've practiced that estate planning was kind of a dog, and the special needs planning was attached to estate planning, kind of the tail on the dog. And we have kind of turned that on our head in our special needs practice. We think anytime that we have a client who has a family member who would benefit from a special needs trust, that ought to be the centerpiece of the planning. So there's usually some estate planning that is adjacent to this, but always we're going to make the special needs trust the centerpiece of the planning to make sure that we cover all of the issues and cover them at a really high level. So I'm going to talk a little bit about that tonight, but not a great deal. What we do at Clarity is help people, define their goals and put in place plans that account for the risks that might be in place, so that they have the tools they need to support life and prosperity, to endure declines in health and well-being, to eventually die, and to do all this with as much ease and dignity. That's true no matter who we're planning for. And I think you're going to get a sense as I talk about the role of trusts in planning that I think trusts are something that can apply to almost anyone who's going to inherit. I think that this is a way to make a difference in people's lives, and that's one of the main things we're doing with our planning. The largest planning, hang on a second. The larger planning issues that we're thinking about when we're thinking about planning for someone who might be a special needs beneficiary is marshaling family resources so that that person who has some disability doesn't lack the services that they need, that they have a structure that enables as much self-sufficiency as possible, which for some people is a lot and for others is less. And then ask the question, who will support and advocate for your child when you are no longer around to do that? How do you define and document those needs? That's part of what we do when we're doing special needs planning, asking the question, what support does your child need to realize his greatest potential? Who will ensure that they receive any government benefits that they're entitled to? And how does the Special Needs Trust work as a tool to assist everybody who's involved in that process? As you may know, it sometimes takes a team to manage this. For someone who is the parent of a special needs child, particularly a younger child, well, you feel like you're a one-man team sometimes, that you're playing every position. We begin to think of it when we're thinking about it in the context of future planning or estate planning, of putting together a team of supporters, advocates, experts, and caregivers, all of whom have some role here. And you need to begin to plan as the parent for the possibility that you might not be that person. Now, everybody needs a plan, but not everybody needs the same plan. And that is a message that we give to all of our estate planning clients, no matter what their situation. So the starting point anytime we're doing planning is asking, well, what are the particular needs of your family? What are the particular needs of your beneficiaries? And so today's topics, if I can jump back, is just to talk about trusts and how they work towards meeting particular needs. Specifically, how does a supplemental needs trust work? Now, a supplemental needs trust and a special needs trust are the same thing. Those are different terms for the same concept. In North Carolina, lawyers tend to use the term supplemental needs trust more than special needs trust. I don't really know what the history or origin of that is, but I'll say that when someone says supplemental needs trust, they mean special needs trust and vice versa. And then I'm going to talk a good deal about issues in trust administration in the context of a special needs trust or supplemental needs trust. Okay, let's start with what is a trust. A trust is a management tool that's defined by a trust agreement, and it's used in gift planning and estate planning. It literally is a contract. It is a contract created by a person. In the context of estate planning, our client might be a parent, they might be a spouse, they might be someone who has no children but has beneficiaries who they want to benefit from their estate, and they want to do it through a trust. So that person creates the trust, this contract, and it is a contract between the creator of the trust and whoever serves as trustee, right? So a contract between the creator, sometimes called the grantor, sometimes called the trustor, and whoever serves as trustee. We kind of think almost everyone should inherit in a gift trust. Trust agreements are in no way standard, but they should be customized to meet the particular needs of a beneficiary. So now I want you to focus on that term particular needs as opposed to special needs. Because, and I'm going to talk about this a little bit in a second, but when we think about special needs, we're not talking about particular needs. We're talking about a particular tool or device. But when I think about particular needs, I'm thinking about any beneficiary. So let's assume we're talking about children. And we'll talk about what those needs might be. I do want to say that a trust, to begin with, is just another way to hold title to assets. Okay, this doesn't mean we are using a trust company or a bank trust department. We could be, but it doesn't mean we are. It means we're going to have a trustee who you, as the creator of the trust, have selected. You will also select backup trustees, people to serve if your primary can't serve. We're not going to necessarily create new or unique assets for this trust. We may have some assets that you have defined as part of a strategy. Maybe you want to leave some life insurance or something like that. But whatever it is, it's not dictated by the terms of the trust, but the use of the assets are going to be controlled and dictated by the use of the agreement that you create with your attorney. So what are the variables for this trust agreement? Well, the first one is, who's the trustee? Second, how many beneficiaries are there and who are they? Is the trust revocable or irrevocable? How's it going to be used? What's the distribution standard? How is it taxed? What are the particular needs of the beneficiary? what happens at the termination of the trust, and what is required to administer the trust. And again, all of these issues apply to a supplemental needs trust or a special needs trust, but all of these issues that you see on the screen apply to any trust that you would use in estate planning or gift planning for any beneficiary. The rules of use differ widely depending upon the goals and also depending upon the type of trust. The biggest difference is the choice of distribution rules. How can the assets be used? When I say this, I mean, how can the trustee you have selected use the assets that you have directed to the trust? Well, one example would be a broad discretionary authority for the trustee to use the assets for support and maintenance. That is not what a special needs trust is, but that might be a standard you use in estate planning for another beneficiary. A fixed stream of distribution. We're going to pay 5% of the trust to the beneficiary every year, whether they need it or not. Again, that is not what a special needs trust is, but it might be the standard. Trustee discretion. Trustee does whatever the trustee thinks is appropriate for the beneficiary. Now we're getting closer to the special needs standard. But when we come to a special needs trust, the distributions are not for special needs. That's not a thing. That's not what we're doing. A special needs trust is one that is fully discretionary, as I described on the prior screen, meaning the trustee decides what to do, but it is structured to facilitate means-tested, needs-based support for the beneficiary. So everyone has particular needs. And so that's the way we think about planning, no matter who we're planning for. And any good trust is designed to meet those particular needs. So, for example, a particular need might be that the beneficiary makes really colossally bad decisions. And so they need somebody else to manage money for them. So you have an adult child, they're a great part of the family, but they're the kid who always makes poor decisions with money. And you think, I'm leaving them a substantial inheritance. I want somebody else to control that inheritance and make decisions about how the money is used and managed because my child doesn't make good decisions. A particular need. Does the beneficiary need incentives to influence behavior? Boy, I really wish my child who started college but never finished would go back and finish college. So I'm going to incentivize them by saying the trust is going to pay for education and it's going to pay for give them a graduation present in the form of a distribution or something like that. Or maybe we want to encourage them to work, or maybe we want to encourage them to save, whatever it might be. The trust can address those particular needs. Does the beneficiary need protection from creditors or divorce? Maybe you have an adult child and you're not satisfied with the quality of their marriage or where there might be a divorce. You don't want to see what inheritance you leave to your child go off with your former son-in-law, your former daughter-in-law. Well, divorce protection can be accomplished in a trust. Maybe you have a child who is in a high liability occupation or profession, and their particular need is asset protection should they get sued for professional liability. Maybe you have a beneficiary who needs a trust to ensure eligibility for means-tested government support while providing resources to ensure quality of life. That's a special needs trust. So I want to lay it out that way because I really think this is a particular need. And the particular need of a beneficiary who needs to ensure that they're eligible for government benefits is not really different from an estate planning standpoint than the child who's a heart surgeon who needs asset protection for potential liability. They have completely different needs. But the purpose of the trust, the particular need, is driven by their particular needs. But the use of a trust isn't driven by that. The particular trust they're getting is going to account for it. And so this is not the same as saying everybody who is a heart surgeon needs the same protection, or everyone who's receiving government benefits needs the same protection. But they do need this particular kind of trust as a tool, and we'll talk a little bit about that. In fact, when we think about special needs, there's not some universally accepted definition of what a special needs beneficiary is or what special needs are. We don't put clauses in these kinds of trusts that say, these are the things that are special needs. No, this trust really just means it's structured, again, to make sure that whoever is the beneficiary has the benefit of the resources in the trust to improve their quality of life, to provide them support, but that the assets in the trust are not going to be countable for the purposes of any means-tested, government benefits. So when we talk about special needs trusts, we're really just referring to the broad consequences of a person's disabling or limiting condition and what the resulting life challenges are, and have we accounted for some support there for them. Now, real quickly, I'm going to talk about government benefits. That's not really the scope of this presentation, but if you think about benefits at the broadest possible level, there are entitlement programs like Social Security Disability, SSDI, and Medicare. And then there are means-tested programs. That's going to be SSI, Medicaid, in-home supportive services, even subsidized housing. So these means-tested programs are the ones we're talking about. And just what I want you to think about is that probably the most important one of these in this kind of planning is Medicaid, but all of them are important if you're receiving them. And as you may know, there are some programs and some support that are only available as Medicaid-based programs that even if your family has a great deal of wealth, you're not going to be able to have a portal to them that's a pay to play. You're going to have to qualify for Medicaid to get to be eligible for the program. And for that reason, even if you have a significant amount of wealth, you might want that wealth to be transferred to your child in the form of a supplemental or special needs trust, so they'll be eligible for Medicaid. I want to talk real quickly about guardianships. Guardianships come in two forms: guardianships of assets and guardianship of a person. So when a guardianship is necessary, it could be someone who's going to have care, or someone who's going to make decisions for another one about life. Or it could be someone who's going to hold assets that someone has for the purpose of controlling them and making decisions and using the assets. We'd like to never be in the situation of needing a guardianship for assets. Any kind of good trust planning, whether someone is receiving government benefits or not, any kind of good trust planning should eliminate the need for a guardian of the assets, unless that something has happened that triggers a distribution to the beneficiary that will not go into any kind of supplemental needs trust. And you'll hear as I go forward that we can have supplemental needs trusts both for assets that are directed to the beneficiary or that come from somebody else. And so usually a supplemental needs trust can cover these for someone who is receiving or might receive government benefits. So let's talk about what you do or how you might plan for someone if you're not going to use a trust. And you're going to see why I think this is not the right way to go if you have someone who you're planning for who is or might in the future receive means-tested benefits. So the options I'm going to cover real quickly are just disinheriting them and not giving them anything, giving their inheritance to siblings or others and saying use the money for them, a spend down so that they're eligible for benefits, the use of an ABLE account, and then we'll talk about the use of special needs trusts, which is the main focus of the presentation. So some people will say, well, their plan for making sure that their beneficiary who's receiving, their family member who's receiving government benefits remains eligible for government benefits is just to not leave them anything in their estate plan. This has the advantage that it works. If they don't have any money, they're eligible for the government benefits. So if you don't leave anything, they don't have any assets and they remain eligible. But it has the downside that, well, they don't have any money for things that aren't covered by government programs. And as I'm sure you know, there are all kinds of needs that a human being has that aren't covered by any kind of government program. So I basically say this is what you do when you don't really understand your options. One thing that a lot of people will say is, my plan is, I've got 3 kids and one of them has needs for government benefits and 2 of them don't. I'm going to choose one of my 2 kids who don't need the government benefits. I'm going to give them the money and say, you take care of your sibling. So if you do that, you give all the money to one of the kids who doesn't need to qualify for government benefits. We have the upside of no loss of government assistance. We have the downside that, well, we've exposed the assets to the creditors of that sibling who we left the money to. We've exposed the assets to the claim of a divorcing spouse if that child were to get divorced. There's the possibility that they might mismanage or even misappropriate the money. There's the possibility they might be overwhelmed. And then probably the most likely of all these, I don't know, one of the most likely of all these possible bad things is that we may not be able to use the funds for the beneficiary who we're trying to help. if the beneficiary who we give the money to becomes incapacitated. So think of it this way. You've got this one child you have complete confidence in. You leave money to them and say, take care of your sister or take care of your brother. They say, great, I'm prepared to do that. And then let's say something happens to them and they lose mental capacity. They're not fully competent. Well, fortunately, they have done some planning and they've got some documents in place like a power of attorney and some other planning. But that power of attorney doesn't account for the sibling. It doesn't allow whoever is the power of attorney for your now incapacitated child to use the money for that sibling. Because nobody ever thought about that, and because the attorney who was planning for the child who got the money wasn't the same attorney who planned for the parents who left the money, and so no one knew that this was part of a plan, and so we haven't accounted for it. There's just no reason to run that risk. We've got too many downsides from this approach. The spend down is just to get the wealth down below 2,000. So if the child who's receiving or might receive government benefits is over that $2,000 threshold in countable assets, we just spend all the money. We pay down debts, we pay things off, we purchase goods and services that are not going to be countable for the purposes of Medicaid, that Medicaid won't provide, and we get down so we don't have any money left. And if we do all that, and we follow all the rules when we do all that, which is not a given. I've seen situations where people didn't follow all the rules and it backfired. But we do that, well, we get down to a point where we might be able to keep the benefits or qualify for benefits if we don't have them. But the downside, of course, is we don't have the money anymore. So the upside, we might be able to retain the government benefits, but we don't have any long-term access to the funds. We don't have any available for support. And it just seems like not the smartest way to proceed when there are other options. The two best options are the last two I've left, an ABLE account and a special needs trust. I don't think the two of these are exclusive. In fact, we usually think of an ABLE account as supplementing a special needs trust. So I'm going to guess many of you have heard of an ABLE account before. If you haven't, you should investigate it. You can have one ABLE account. The beneficiary is actually the account owner. There are limitations to what you can contribute every year to that account, $17,000 per year. There's a maximum of $100,000 that you can put in this account. If you go over $100,000, the account becomes countable for the purpose of government resources until you spend back down under $100,000. One of the big negatives of an ABLE account is if there's any money left in the account at the death of the owner / beneficiary, well, then it's paid to the state to reimburse the state for any benefits that have been received from Medicaid. An ABLE account is not for everyone. It's only available to people who had a disability before the age of 26. And it can only be used for qualified expenses. Now, it turns out that the qualified expenses are a pretty good and robust list. It includes education, housing, transportation, employment training and support, health prevention and wellness, financial management, legal fees. We always love it when the legal fees are included in the rules, funeral and burial expenses. So a lot of things that are things that people might need. The income can be tax-free in this ABLE account as long as it's used for those qualified distributions. No gift tax associated with this. The beneficiary is able to save and manage their own account. They have a sense of control, which is a positive, sense of self-worth that is a positive, and they've got easy access to the money. So we think almost always that an ABLE account for a beneficiary who is able to manage it ought to be part of the strategy, but you've got to be savvy about what the downsides of the ABLE account are. So it makes sense for a person with SSI or Medicaid, for a person who's capable of managing their own finances. It is ideal for a person who receives a small kind of unexpected inheritance. I had a client last year receive a large unexpected inheritance. What happened is his grandfather died, and grandfather left everything to his three kids, but it turns out that one of the three kids predeceased his father, and that was the father of my client who was receiving government benefits. And the estate plan, not thinking about this issue at all, said, well, gee, I leave everything equally to my children, and if any of my children predecease me, their share goes to their children. So now my client who was receiving government benefits received a substantial inheritance from his grandfather, and we had to do something about it. Now, in that case, that inheritance was well over $100,000, so we needed to use a trust, and we did. But if that inheritance had been $15,000, we would have used an ABLE account instead as a simpler and very flexible alternative for a beneficiary who, in that case, could manage his own money. So again, for a small inheritance, maybe a small litigation settlement, a surplus in income, maybe under SSI, you're going to throw it into an ABLE account as a means of keeping it from being counted against qualification for any government benefit from exceeding the resource limit for SSI or Medicaid. Now, this may also, in fact, we believe it makes sense in conjunction with a self-settled special needs trust. And one of the reasons is the rules are more favorable for the use of funds at death. An ABLE account is available to pay expenses associated with someone's death. We're not going to be able to do that with a special needs trust. So we might use an ABLE account and a special needs trust hand in hand for that purpose. I will say, and of course, ABLE accounts are not brand new, but but in the big scheme of things, they're relatively new in the planning horizon. And so there will be a lot of older special needs trusts around which won't account for this. But when we're doing a new special needs trust now, we always want to provide in the trust that the trustee can take money from the special needs trust and move it into an ABLE account. And so in this sense, I want you to begin to think of an ABLE account for a family that has resources of $100,000 or more, as not the ABLE account isn't an alternative to the special needs trust. It's a tool that works hand in hand with the special needs trust. And in most cases, you'll want to use both. Let's talk about special needs trusts. Special needs trust like this applies regardless of the particular needs of the special needs beneficiary. This can be any kind of disability. It doesn't have anything to do, the trust document doesn't have anything to do with what the money is used for or what the health of the beneficiary is or anything like that. It's purely a device for creating a fund to be used solely in the discretion of the trustee for that beneficiary, with the idea that if it's managed correctly, we're not going to result in those assets being countable, so we won't lose benefits or we won't be in a position where we're ineligible for benefits that we apply for. So again, a special needs trust does not refer to a trust designed to provide for particular special needs. It's just a trust designed to protect the interests of the person whose particular needs include they've got to qualify for government benefits. So now we're able to receive an inheritance, receive a gift, have a substantial fund to enhance the quality of life, to provide support, but not disqualify the person for the government benefits. As I said before, when we're talking about a special needs trust or supplemental needs trust, we are talking about a trust calculated to improve their life by ensuring compliance to preserve the benefit. It's a way to stay in control. There's three parties in connection with a trust: the trustor or grantor who creates the trust, the trustee, and the beneficiary. Assets are overseen as to management and distribution by a trustee who's picked by the person who created the trust. Your loved one receives financial support, but the assets are not owned by the beneficiary. They're used for what that person wants, but not their needs, and they're paid out over time. They're held in trust and used as needed. This maintains the government benefits. It also protects the assets from their creditors or people who might take advantage of them, or protects them from mismanagement. It also means that it protects against financial abuse or any other kind of abuse that might come to that person over the course of their life. And it provides additional funds for their support and benefit. It can enhance their lifestyle. It can enhance their care if they need care. And the great news about this from a standpoint of planning is it can be a device that receives gifts or distributions from multiple people. So if you're thinking, well, I have a child who would benefit from a special needs trust, and I also have some parents, the child's grandparents, who might like to make a gift to them. Well, you can create a special needs trust that will be the place where the inheritance you leave your child goes, but can also be the place where a lifetime gift from your parents to go to the child, or it could be a place where a gift from their estate plan goes. So one trust for gifts from multiple sources. In fact, for that kind of special needs trust, which I'll talk about in a second, the money can come from anyone except for the beneficiary themselves. So the requirements for a trust like this to work, you've got to have a third-party trustee, which is to say, no matter how capable the beneficiary is, they cannot be their own trustee. Second thing that is a little hard to wrap your head around is the beneficiary can't have any enforceable right. So when I think about a special needs trust, I think about it this way. The trustee has complete discretion with respect to distributions. Typically, they can only distribute the money for this beneficiary, but they don't have any obligation to distribute the money for the beneficiary. And of course, they have a duty to distribute it in a fashion that's not going to cause them to lose their benefits. Again, the assets are only available in the discretion of the trustee. Certain types of special needs trusts can only have one beneficiary. The trust must be correctly used. And because these kinds of trusts are irrevocable, they can't be easily modified. Okay, so let's talk about that next to last one. I'm going to come back and talk about this again, but I want to talk about how this works. This works to keep the assets from being countable because they are compliant. But what are they compliant with? Well, they're compliant with the Medicaid rules or whatever benefit, whatever program we're talking about. But they have to be compliant in two ways. The document itself needs to be compliant, which is to say the attorney who drafts it needs to know what they're doing and put language in it that makes it compliant. But then they also have to be used by the trustee in a compliant fashion. What do I mean by that? Well, I guess what I'm saying is this is a fully discretionary trust. And so the trustee theoretically has the discretion, not theoretically, does have the discretion to use it in a fashion that's not compliant. But in fact, part of what makes it work is the fact that the trustee has discretion. It's a fully discretionary trust. So what I would say is the document itself has to be compliant. That's the responsibility of the lawyer. But then the trustee has to be compliant in the way they use the money. And that's something that if we're the lawyer, we're going to make sure we help the trustee with. We're going to be a resource for the trustee. We may even do some training for the trustee. But ultimately, the trustee has to use the money in a fashion that is compliant. The assets in a special needs trust are not countable for the purpose of means-tested benefits, so long as the trust is properly administered. Again, compliance is how it is drafted and how it's used. The trustee has to use the assets, so distributions don't result in a penalty or disqualification. Types of special needs trusts. A first-party trust created by the beneficiary, the person who is receiving or might receive government benefits, created with that beneficiary's money, not necessarily created by the beneficiary, but created with his or her money, funded with his or her money, and funded with his or her own money only. There's a third-party trust. That's a trust funded with money from anybody else. There are pooled special needs trusts, which are just administered differently. And then there's something called a qualified disability trust, which I'm barely going to talk about, but I do want you to know it exists. First-party trusts. The beneficiary has their own assets. They are going to take those assets and put them in an irrevocable trust because they are or are about to be over the resource limits, or they are trying to qualify and they are over the resource limits. And they are able to put this money in a first party special needs trust. There's not going to be a penalty for the transfer. The assets are going to, go away. They're not countable now for the purpose of benefits. This is an irrevocable trust. We can't change the rules. We can't have the money back. It has a Medicaid payback provision in it, and it has to have a Medicaid payback provision. In effect, a provision in the document that says if there is money in this trust when the beneficiary dies, Medicaid is going to be reimbursed for the benefits the beneficiary has received from Medicaid. It's for that beneficiary's sole benefit, which is to say there can't be more than one beneficiary of this trust. It's only for the person whose funds were put in the trust. And the beneficiary has to be disabled within the meaning of the Social Security Act, unable to engage in any substantial gainful activity. So not all beneficiaries may qualify for a first party trust, but it is not. Most of the beneficiaries that we plan for are able to do this. By the way, this is only for people under the age of 65. So if a beneficiary is over 65, they can't create a self-settled first-party trust or a trust created by someone else that issues with their money and therefore is a first-party trust. The payback provision, that's for medical care only, which is to say Medicaid, not SSA. So we're not reimbursing for the support. We're just reimbursing for medical care. Medicaid is paid back. Taxes that are due are paid. The expenses of administering the trust is paid, but everything else goes to Medicaid. Okay. And by the way, the Medicaid reimbursements that are required from a first party trust like this don't just involve the distributions from Medicaid after the trust is formed, but all of the distributions the beneficiaries receive from Medicaid over their life, including benefits they received before the trust was formed. If you've moved from one state to another, it includes the benefits from other states, not just the state the person is living in at the time of their death. So who can create the first party trust? Well, this is a little more liberal than it used to be. A parent or grandparent can create it. A legal guardian can create it. A court can create it. Why would a court create it? Well, maybe it relates to a personal injury settlement or something like that, and that's the source of the money. And in a change in the law a few years ago, the beneficiary can now create this trust himself or herself. And if the beneficiary were not mentally competent, well, if the beneficiary's power of attorney allowed it, the beneficiary's power of attorney could probably create it. So again, I mentioned an award from personal injury as an example of what might be appropriate for a first party trust. I also mentioned an inheritance like the one I dealt with last year that would certainly be appropriate. That's what we did in that case because the ABLE account wasn't robust enough to handle the amount of the inheritance. This can be, some maybe child support payments, any money received and not spent immediately that would be over the resource limit can go into this first party trust. So again, as I mentioned, if you have a legally competent potential beneficiary, they probably ought to have a power of attorney, and they probably ought to have a healthcare power of attorney. The durable power of attorney for financial and legal matters probably ought to allow the agent to create a self-settled trust. So even if you don't have a need for a special needs trust now, or think you don't, you may have the need to have the beneficiary create a power of attorney that will allow their agent under their power of attorney to create a self-settled trust for them. And you might think, well, if they need one, I'll create it. Well, they might need one after you have died. And so we might want to make sure that they have someone who can create it for them once you are gone, if we're not going to create it now. And I will tell you, as we go through this list of trusts, sometimes when we're doing robust planning for a family, we're going to do a third party trust because that's the heart of the use of this kind of trust in the estate planning context. And then we're going to create a first party trust, even though we don't expect to use it. So we'll just have it in case. So it'll be sitting on the sidelines, already formed in case we need that. Why would we do that? Well, that's because typically if someone's receiving the benefits, they can only hold this extra money so long. They need to get it out of their account within a short period of time, usually less than 30 days. And so we may not have a trust. So it might be nice to have one in our hip pocket that we can pull out and use for that money that has come in the door. Third party trusts funded by assets that the beneficiary doesn't own. Anyone can create this trust. It doesn't have to have any particular definition of a disabled person. It can be part of the parent's estate plan. Built inside their will, built inside their living trust. It can be a freestanding document created now for lifetime gifts that also receives money at death. The rules of this trust are that the trustee, who is picked by the person who creates the trust, has broad discretion to make distributions. You can have more than one beneficiary of a trust like this, although we rarely do that. We usually just do one beneficiary. And this last point should probably be in all caps. There's no Medicaid payback from a third party trust. So if we're leaving an inheritance to a beneficiary, it goes into the trust, it's used over the course of their life, and there's money left in the trust when the person dies, well, that money is not going to go to reimburse Medicaid, or it's going to go where? Well, wherever the plan says it goes, maybe to a sibling, maybe to the next generation, maybe to a favorite charity or a family friend. So when you create this third-party trust for your beneficiary, will be able to dictate who gets the money if there's any left. When you think about it strategically, and one of the things I talk about with people in estate planning all the time is, well, how much money do I need to put in a trust for my child who's got a need for a special needs trust? Well, sometimes there's not a clear answer. Sometimes there are inadequate resources. Sometimes I've got the parent has 3 kids and they've got $600,000, and their instinct is, well, let's divide my $600,000 estate 3 ways, $200,000 to each of my kids. But then they go, well, I'm not sure that's enough for my child who has the need for a special needs trust. They may need more, but I don't feel great about having an unequal inheritance. Well, part of the answer to that can be, if we give the special needs trust more than the proportionate share we just talked about, it's there if the beneficiary needs it. And if the beneficiary never needs it over the course of their life, where is it going to go? Well, it's going to roll back to the siblings, or if the siblings have died, maybe to the siblings' children. And so it's, in a way of evening up that inequality, while at the same time sort of overfunding the special needs trust to make sure that every conceivable need there is met. That's part of a conversation with your estate planning attorney, but that is one of the advantages you've got with a third party trust. One of the other advantages with a third party trust is that it can be funded both during life and at death. So you could create a trust like this. You could make a lifetime gift transfer to it. You could set up a life insurance policy to pay into it at death. You could inform other family members, hey, if you'd like to leave something to your grandson, your granddaughter, your niece, or your nephew who is the child who has these special needs, well, you can leave it in this trust and it won't disqualify them for any benefit. So it become a family device, no obligation. One of the things we do for our clients is we'll send out a letter to other family members saying, we're not soliciting gifts. We're not asking you to make a transfer for our child. We're just saying, if you're going to do it, let's do it correctly, and let's do it to this trust. Here it is. Here's how it works. If you need to contact my lawyer to get more information about this, please do that. So again, this can be created and funded during life. It can also be created and funded at death. Anyone except the beneficiary can contribute assets to the trust. Pooled trusts work just like first party or third party trusts, but a nonprofit organization manages them for investment purposes. There's not a family member or someone picked by the family member serving as trustee. This is something we do usually when we have a modest amount of funds and we want to get the benefit of pooling the money with other beneficiaries in a similar situation, so that we're able to set up this kind of trust without going to unnecessary cost. It will require the action of a parent, grandparent, or guardian to establish it. It's perfect for someone with too many assets to be eligible for the means tested benefit, but not enough assets to warrant a custom drafted special needs trust. And so you're probably thinking, well, how much is that? And I got to tell you, I'm not sure I know. I certainly think that any gift of $100,000 or more is enough to justify a special needs trust. So it's probably less than that. And a pooled trust is also something that can be used in conjunction with an ABLE account. Now, a qualified disability trust. This is something that's going to be complicated to understand, but I see it apply more and more. So suppose the parent or grandparent of the beneficiary we're talking about is themselves thinking about their need to qualify for Medicaid for long-term care, and they are worried that their assets are going to keep them from qualifying. One of their goals is to leave enough money for their child or for their grandchild who is receiving government benefits themselves. Well, it turns out that they can transfer money to a trust for the benefit of the child or grandchild we're talking about. And not only will it provide special needs support, but it will not be treated as a disqualifying gift for the parent or grandparent. So what am I talking about there? Well, when you're doing that kind of planning, any gift that is made within a 5-year period, a 5-year look back period before applying for Medicaid will be penalized, will be treated as disqualifying. And what we're saying here is that if that parent or grandparent has a disabled child or grandchild and they transfer the money to them, there won't be any look back period, there won't be any penalties, so we're able to use this qualified disability trust in those unique circumstances. Let's talk about the rules for the trustee, how this works for the trustee. Well, I said before, the trust language, the trust agreement, the document has to be compliant, but the trustee has to be compliant in the way he or she uses the assets. First rule is we can't ever give the beneficiary money. We can't say, here, I'm going to, it looks to me like you got a couple of $1,000s of expenses every month. I'm going to give you a couple of $1,000s and you spend the money. Why can't we do that, particularly if we have a beneficiary who's fully capable of making good decisions with their money? Well, the answer is because we can't prove how the money is used, and there are disqualifying distributions, and the trustee has to be able to prove that the money wasn't used for an improper purpose. So it has to be used for services not covered by Medicaid. We can't use the distributions for food or shelter, well, we can't use it for food almost ever. We can use it for, there are a few instances where we can use it for shelter. So the trust doesn't say, gee, we can't use it for these things. The trustee needs to be informed and educated enough to know that they can't use it. They need to be informed enough to know that they can't give the money to anyone who is going to use the money in their discretion, but rather the money needs to be used in the trustee's discretion. So what kind of distributions are permissible? Well, household services, house cleaning, things like that. Internet services, entertainment, streaming services, a telephone bill, professional help. Again, we get to pay the attorney's fees. That's exciting news. Caregivers, planners, accountants, tax preparers, advocates, financial planners, personal care, someone who helps with laundry or hair care, massage therapists, medical equipment, exercise equipment, furniture, computers, musical instruments, tickets to entertainment events. All of these kinds of things are acceptable expenses. So the trustee can buy these things, can pay bills for these things, can acquire these things, but they're going to want to pay for them directly when they're using the special needs trust. We can use the money for a vacation. We can use the money for education. We can use the money for pet care. We can use the money for transportation. We can even use the money to pay a credit card bill as long as the credit card wasn't used for improper expenses. Everybody, I'm going to take about a 2-minute break. I've got a 14-year-old dog who's trying to walk down some stairs, and she is having a hard time seeing because we're in outdoor light. So I'll be back in 45 seconds after I help her down the steps. Hang on just a second.
No worries. Thank you.
Hey, Sophie, come here. There we go. Good job. Good job. Sophie doesn't know this, but she's having surgery tomorrow morning, so I feel really bad about that.
Oh, sweet girl.
Okay, now, thank you for that break. So what does a trust agreement like this say? Well, it should state that the funds in the trust are to supplement and not replace any government benefits if someone's receiving them. It's not going to give a laundry list of the things it can be used for, but it's going to suggest that it's not for support and maintenance, that it's fully discretionary, that the trustee probably shouldn't use the money for food or shelter, but probably the trust language wouldn't prohibit that. The language we'll use is literally what you see up on the screen. My trustee may apply for the benefit of my beneficiary such sums of income and principal as my trustee, in his or her discretion, shall determine from time to time for my beneficiary's supplemental needs. And if you think that doesn't really say anything, there's a way it doesn't say anything. It's just saying this is to be used in the discretion of the trustee. We can fine tune that a little bit. So we might see a trust that says supplemental needs shall include, but are not limited to, the medical, dental, and diagnostic work and treatment for which there are no private or public funds otherwise available, medical procedures that are desirable in my trustee's discretion, supplemental nursing care, rehabilitative service, housing in institutional settings, care appropriate for my beneficiary that's not otherwise provided, travel, companionship, cultural experiences, educational experiences. These are just examples of what might be available uses, and we might put that language in the trust. My trustee is prohibited from expending any of my trust income for principal or for property, services, benefits, or medical care that is otherwise available to my beneficiary from any government source or from any private insurance carrier required to cover my beneficiary. So, how does a trustee figure all this out? Well, they're going to want to make sure that they get some good help working with some advisors. On the one hand, at death, a self-settled trust goes to reimburse Medicaid. We talked about that before. A third-party trust doesn't go to reimburse Medicaid. So what if we had both trusts? Well, then if we had both trusts, the advice that we would give the trustee is spend the self-settled trust first. We've got a first-party trust and we've got a third-party trust. We've got money in both. Well, our goal would be to have nothing in the self-settled trust when the beneficiary dies, because that trust goes to reimburse Medicaid, but the third-party trust doesn't. So the third-party trust would be the last money spent. It's typically in our planning the larger trust too. So we're going to manage the third-party trust also to avoid income. Why are we going to do that? Because income can be a qualifying issue for government benefits, and the income in a trust is taxed to the trust, and so therefore it doesn't have any, in this case, it doesn't affect the beneficiary's eligibility. However, the trust tax rate is very, very high. So for example, let's suppose we've got $100,000 in a first-party trust and $300,000 in a third-party trust. You've already heard me say, well, let's spend the first-party trust first. And so that's a strategy that we want our trustee to understand. But here I've got another strategy. Let's see if we can manage the third-party trust, which we are not using until we have exhausted the first-party trust. Let's see if we can manage that money to incur capital gains, but not interest and dividends, because the interest and dividends could be subject to a high tax rate inside the trust, which could be alleviated if this were a trust for somebody not receiving government benefits by distributing the income. Because if we distribute the income to the beneficiary, it's on their tax return, not on the trust tax return. So we might have a beneficiary who's going to be taxed at 25% and a trust that's going to be taxed at 35%. Well, we'd rather be taxed at 25%. And if the beneficiary is not receiving government benefits, that's no problem. But if the beneficiary is receiving government benefits, we've just increased their income, so we can't use that as a strategy. So this backup strategy is, well, let's try to figure out a way to manage the money without having income. And then another thing that we always want to advise people is buy a prepaid burial plan. Because that is something that the trust can own, but as you heard me say before, the special needs trust can't be used for funeral expenses or burial expenses. So we are able to indirectly use the trust for those expenses by buying the prepaid plan, holding it in the trust, and using it at death in that way. So again, just some strategies that the trustee is not going to intuitively know, but can apply to effectively using the trust. Common misconceptions. Special needs trust planning is poverty planning, that we're trying to make people poor, or that it is only for people who are poor. Nothing further from the truth. We use this planning for clients of all levels of wealth. It is a way to make sure that the needs of a beneficiary are fully met, and that the wealth of the family is preserved, whatever the level of wealth is. Uh, Another misconception: not many families do this type of planning. We see it all the time. It is a big part of planning. It's costly. It's expensive. Trusts are only for the wealthy. Again, no. This is something that we've done for people with $30,000 or $40,000. I would strongly recommend it for anybody who has $100,000 or more. Siblings and other family members will simply care for your loved one, and you don't need to worry about it. You know, yes, that might be true. And if everything goes well and exactly as expected, that might work. But things don't always go well. Unexpected things happen, and you don't want those unexpected things to undermine the care for your loved one. Beneficiaries won't need any extra benefits. Well, there'll always be a use for extra benefits. So I think it's a good idea to have this fund available. I hear this a lot. It's too soon. The planning's not really needed yet. Well, I don't know. I don't know when the planning is needed. I don't know when you're going to die. I don't know if you're going to become incapacitated, but I do know it needs to be done before you die. It needs to become done before you become incapacitated. So I don't see much downside to doing it earlier. It works like an insurance policy. If you do this planning now and you don't need it for 30 years, well, you had it for 30 years just in case you need it. And unlike a lot of planning, you know that at some point you will need it. I want to talk real quickly about a TrueLink debit card. I don't know if any of you have ever heard this, but this is something we use with beneficiaries who are able to make good decisions about money as a means of making sure that we know how the money is spent. I said before, well, we can't just give them a couple of $1,000s to walk around with, but we could give them a debit card attached to an account in the trust. A TrueLink card is a particular kind of debit card that has been approved by Medicaid that essentially is set up so that it can't be used for any improper purposes. So if you had, let's say, well, you can't use supplemental needs trust funds for food. So does that mean you can't use the debit card at the grocery store? No, there are all kinds of things you can get at the grocery store that aren't food. It just means that when you go to the grocery store and you try to check out with the debit card, it's only going to be usable for things that aren't prohibited. It's not going to be used for your groceries. So that is a way to give the beneficiary some control, and with that control is more satisfaction over the quality of their life, maybe a little more dignity associated with the whole thing, and that's a good thing. So it's a good way to support the beneficiary who's able to use that debit card. Again, the trustee owns this card. The beneficiary is just an authorized user. The card can't be used for cash either, because again, once it's used for cash, we don't know how it's spent. But it does work to provide appropriate distributions and know how the money was spent. So my goal hasn't been to confuse. My goal has been to enlighten you a little bit. But you may be asking, well, so you just told me a bunch of different kinds of trusts. Which one do I need? Well, the last one, the qualified disability trust, is just highly specialized. So that's only if the person transferring the funds is looking to qualify for long-term care benefits themselves. The pooled special needs trust, that's going to be if you're looking for a way to have a special needs trust at a much lower entry cost. It has the disadvantage that the money isn't going to be able to stay in the family if there's money left in the trust at death. So you're only going to want to use that with a relatively small amount of money. Third party or first party, it's pretty self-explanatory. If the money is going to come from anybody other than the beneficiary, it's a third-party trust. If it's going to come from the beneficiary's own money, it's a first-party trust. I mentioned, and I probably glossed over it a little bit, this trust can be in your estate plan, which is to say it only arises after your death. So it can be a subtrust inside the living trust, or it can be a testamentary trust inside a will, and it says, gee, at my death, divide my money among these 4 people, and one of them is a person who I want their quarter to go into a special needs trust, and here are the rules for the special needs trust. Or it can be done as a trust that you create now that is available for lifetime gifts and gifts at death. So that's not determining whether you need a first party trust or a third party trust. All of those kinds of trusts are third party trusts. As I mentioned before, sometimes we use multiple trusts, what we sometimes call a team of special needs trust or special supplemental needs trust, a subtrust in a parent's living trust for the primary inheritance, a standalone third-party supplemental needs trust for lifetime gifts from anyone, other family members, even testamentary gifts from other family members. Grandparents' will says, give $25,000 to my grandchild. Annual exclusion gifts. You're making annual transfers under the annual gift tax exclusion to the beneficiary in this trust. It is a good reason to have a freestanding, standalone third-party trust. Required minimum distribution from retirement accounts that have been directed to the beneficiary as well. And then a first-party trust for things that slip through the cracks, money that we didn't anticipate the beneficiary themselves having, but we have a trust ready for it in the event that comes up. So again, I hope I haven't left you overwhelmed, but maybe a little bit enlightened. If you have questions, I'm happy to talk about these things. One of the things I really didn't talk about, because I think you understand the impact of getting this wrong, is the loss of benefits and or possibly having the wrong people in control. Just family stress, family tension, confusion, and we don't want to deal with that. You want to get professional assistance not only when you're setting this kind of trust up, but you also want to have professional assistance in administering a special needs trust like this. You may also want that trustee working with a benefits advocate, a tax accountant, a financial advisor, an insurance agent, all people who can be involved in funding it, managing assets in the trust, dealing with the tax issues for the trust. If you're working with us at Clarity Legal Group, we have a 5-step process. We start with a basic consultation about what the plan might look like. Our next step is we put the planning draft documents together, but we're putting together what we call a working draft. The third step is you would sit down with us and actually review draft documents. We'll talk about how they work. We'll look at the language. We'll look for additions or changes that the client wants to make. And then the fourth step is we'll again review the document. We'll sign the documents, and we'll put together not only the legal documents, but also whatever funding is appropriate for reorganizing assets in connection with the plan. We're going to provide lifetime support for the administration, not only of a supplemental needs trust, but of any kind of estate planning we do for our client. Hopefully, you're going to end up with peace of mind necessary to turn your knowledge into action. And I'm going to open the meeting to questions if there are any. I apologize if I wore you out.
Let me see if my camera will come back on. Not at all. So much information. I'm the mom of an 8-year-old. She just turned 8 on Saturday. And I know another mom on tonight. We're like, we need to start taking in all the information. There's so much to know and so much to clarify. So thank you for being a part of that and doing that for us tonight.
Sure.
I did want to open it up to anyone still on if they wanted to unmute or raise their hand to ask any questions. Nothing came through on the chat. Let me check again there. So yeah, we'll just give anyone a few minutes if they have a question to put it in the chat or just to unmute. Make sure I don't see any hands raised. Oh, and I love ending on that note, remembering to educate others, spread it to everyone, families, friends, community spaces. All right. Oh, we got a typer. We got a typer. I was getting ready to give it the final call. We'll give you time, Kara. Take your time. Take your time. I think we might actually have it set up to not. Super informative. Thank you so much.
You're most welcome. Again, I know it can feel, this kind of stuff can feel like you're getting a fire hose coming your way, and it's too much information. Believe it or not, this is a pretty narrow presentation on these subjects. I have a version of this presentation where I take a deep dive into all the various benefits and how all the benefit programs work with this, and that is way more complicated. This is complicated enough. I think that ultimately, you want to work with an attorney who really understands this stuff. We are not the only ones by any stretch of the imagination who do. I always like to say this about special needs planning. Not every estate planning attorney is a special needs planner, but every special needs planning attorney is an estate planning attorney. So it can be kind of hard to find the right person. And so you're going to want to, if you're working with, looking at any attorney, you're going to look to see if they have real experience with special needs planning. And sometimes it's hard to figure that out, but you're going to want to work with someone with a little experience.
Absolutely. Thank you so much for sharing that. Is it possible to get some of the slides or information shared in the presentation? You will be getting a video, and then do you share your slides, Mark, or not to put you on the spot about that?
We actually may not be able to do that because the images are licensed only for this purpose, and so we can't control how somebody's going to use it.
Correct.
It's kind of like the special needs trust. You can't control how the beneficiary is going to use the money. That's why you can't just give it to them.
You can't just give it to them. Correct. What a great little segue. But yes, you will. Those that are registered will get a protected link for what he covered tonight. So you will be able to access this information again at any time. Any other questions before we close out tonight? All righty. Well, if anyone does have a question, there will be a follow-up email with a survey just to solicit some feedback as we plan future sessions to meet the needs of our families. And if you have a question, you can address it during that email. And Mark has so graciously offered to answer and address those questions and needs. So again, thank you, Mark. Thank you, Clarity Legal, for all that you do for our families and all the families that you serve, and for being with us tonight to share all this expertise. Now we can muddle over and probably take some time to come at you with some email questions. But just thank you for being willing.
I can't tell you how happy I am to do this, and we would be happy to speak again or in a different context, and be happy to answer questions if anybody has them.
Awesome. We will keep you in our list for conference, for future virtual series. But just thank you for a great night, and Thank you all for joining us. Hope you have a great Wednesday.